Good afternoon. My name is Allison Baker. I'm a partner and co-head of Venable's Consumer Financial Services practice, and welcome to our Consumer Finance Enforcement Activity webinar this afternoon. I am really excited because we have with us a fantastic panel of experts who work in the consumer financial services space and specifically handle enforcement cases that are brought either by the Consumer Financial Protection Bureau and or the state attorneys general. And today we're going to be talking a bit about what we're seeing right now. Trends in enforcement actions by the CFPB, recent state consumer financial protection enforcement activities, best practices when you or your client receives a CID. How do you handle it? What do you do? What are the first things you do, the second things you do, et cetera? What are some of the changes that we've seen recently in the Consumer Financial Protection Bureau's civil investigative demand world, including and especially how its civil investigative demands are how they describe the alleged conduct at issue. And finally, we're going to talk a bit about the interplay between the state attorneys general and the CFPB. And I'm joined by my colleague and partner, Jerry Sachs, who is an alum of the CFPB, as am I, and also of the Federal Trade Commission. Jerry is, and also was an assistant U.S. attorney in the Northern District of Georgia. I'm also joined by my partner, Meredith Boylan, who is also an alum of law enforcement, having been an assistant district attorney in New York. And finally, we're joined by two of our colleagues who are associates who work closely with us in handling consumer financial services enforcement actions, Erin Cass and Liz Reinhart. Thank you so much. Now, Jerry, if you can just kind of give us the lay of the land in terms of some of what we're seeing recently with respect to enforcement actions by the CFPB, the new regime, if you will, under Craniger, and some other things that are emerging over the last 6 months or so.
Absolutely. Thank you, Allison, and hello to everyone on the webinar. The enforcement was quite a tool in the past, and it still is likely to remain somewhat of an effective CFPB enforcement tool. It might just be a little bit duller than the sharp blade that it was a couple of years ago. The new director, though, has made clear that she does not believe in no enforcement. However, she does believe in taking some actions with certain parameters. And as she mentioned at a recent presentation at the Bipartisan Policy Committee meeting, or center, excuse me, she said that, enforcement will not be used to make rules on a case-by-case basis. And that's, quite frankly, a very welcome statement to many in the industry who have had to deal with allegations of UDAP based on compilations of data that they may have possessed but not have compiled in the way that the enforcement office of the CFPB had done. And so part of what Director Craniger laid out is that enforcement will be an essential tool to ensure justice is served in the public interest and hold bad actors to account while simultaneously sending a deterrent message. But what she has also said is that the Bureau will focus on rule writing and education as sort of the first steps in helping to solve problems and issues in the consumer financial services space. And I think some of that stems from her background as a Peace Corps volunteer and providing education to others. So, educating people to help them prevent being taken advantage of. I don't think that means that the CFPB will do nothing when people are taken advantage of. I think the director was pretty clear that there will still be times when enforcement action will be necessary. However, it will come about in a more concerted effort to reinforce clear rules of the road and prevent harm. So that kind of dovetails into what the CFPB is doing more recently, which tomorrow they will be holding their first UDAP forum to help decide how to better define or not define abusiveness. It's kind of unclear where that will lead in the future. Enforcement will also be used to, deter unlawful behavior, level the playing field, and support a just outcome for harm to consumers. That seems to read similar to messages that Rich Cordray sent out in the past under his tenure at the CFPB. It will be deliberate and take months to investigate to find violations. that is probably the least welcome news, that something could take months or years of investigation to come to a resolution. And Director Kraninger said that enforcement will be careful and purposeful in its investigations to be fair and thorough and evaluate all the facts in the law. I guess, my response to that is time will tell. We'll see how that plays out. One could only hope that the Enforcement Office will more thoroughly evaluate all of the facts in relation to any business conduct and not just the facts uncovered through their specific questioning or investigatory tactics. Again, time will tell.
Jerry, I have a question for you. You seem to be hitting on a theme that I think we agree is kind of interesting to this director, this theme of transparency. I think the hearing that she's convened for tomorrow on the abusive standard is probably a move in that direction. What do you think about that, given your extensive experience in the consumer finance enforcement space?
That's an interesting question, Alison. I think abusiveness is clearly defined. I shouldn't say clearly. It is defined in the Dodd-Frank Act. Some would say it has set clear rules. Some would say that a lot of the terms that actually define abusiveness are not well defined themselves. I think what the Bureau is doing is responding to a lot of people in the industry who voiced a lot of concern and chagrin, for lack of a better way to put it, as to the previous tenure director at the CFPB and the tenure of the Enforcement Office during that time, which would allege abusive sort of as a big stick to entice settlement. But at the same time, it's pretty clear to anyone who looks at, I think the Bureau has brought in the past 31 separate cases where abusiveness was used. There might have been some overlap with some individuals and corporations there, but abusiveness has always been used at the same time as unfairness and deception. So while it is going to be defined, there is some question of how effective or how relevant is abusiveness when it's just an overlap of unfairness and deception. I think tomorrow's forum will delve into whether there is a need to define abusiveness or maybe issue policy statements, or continue along the path that we are moving along right now, which is to let case law develop it on its own and maybe look at it again in a number of years. I mean, if you look back at what the Federal Trade Commission did with unfairness, of course, there were policy statements. There was first the cigarette rule, and then there were policy statements, and then there was some codification, and that occurred over 2 to 3 decades, if I remember correctly. So, it will be interesting to see the outcome of the panels. There's one panel of current CFPB personnel and academics, and then another panel of practitioners and previous CFPB attorneys and some academics as well. So it will be interesting to see what the outcome is. We won't know at the end of tomorrow, but we'll have a good indication in the future.
One thing that Bureau did a lot of in its early years, and we know this having been on the ground doing it with them in the enforcement offices, there was a real urgency to build out the UDAP doctrine. So the unfair, deceptive, or abusive acts or practices doctrine under the Consumer Financial Protection Act is a unique new cause of action or series of causes of action. Deception and unfairness tack a little to the FTCA, but also have their own uniqueness. And there was a real instinct at the Bureau to build out those doctrines through common law, and a real resistance to writing a rule that describes what abusive is or what deception is or what unfairness is. I wonder, Jerry, if you think tomorrow is going to be unveiling some movement toward perhaps writing a rule or in that direction. I would be surprised, but you never know.
You never know. It's interesting because the current administration is very deregulatory, so writing a rule would seem to be the opposite of that. However, at the same time, allowing UDAP to develop on a common law case-by-case basis really provides a lot of leeway to district court judges across the country and various appellate courts, depending on the circuit. And we've heard the current administration rail against the judiciary. So at the same time, there's sort of this deregulatory movement, and there's this don't leave things up to the judiciary and let the executive or independent executive branch maybe decide things. So I'm unclear or uncertain as to whether a rule will come out of this or not. It seems to be a predicate, at a town hall or a forum to obtain information and move in that instance. I find it's very seldom that the government holds a meeting and then does nothing. It does occur, but usually It's to hold a meeting, a town hall, as the CFPB would do in the past, and then use that to develop further rulemaking. And something that I found that was interesting when I looked at the overall trends were that I took the 2017 from January to June roughly during Rich Cordray's tenure, and then I took from the current director's tenure from January to June of last year, and compared the enforcement actions. There were 22 under Rich Cordray, and only 12. Excuse me, that appears to be a typo on my part there, but 12 enforcement actions during the current director's tenure. However, when you look at the restitution and the disgorgement, they are very similar. There was roughly about $148 million in restitution under Rich Cordray, and there was actually a little bit more, closer to $180 million in restitution under Director Kraninger, and however, 168 of that million came in the form of forgiving outstanding student loan debt. Now, I say that because when you take that out, the restitution drops drastically. But during Rich Cordray's time, there was student loan forgiveness for some for-profit colleges reached in a settlement, and so that was included in those restitution numbers. So when you're comparing apples to apples, the first 6 months of the new director seemed to be getting more restitution and comparable civil money penalties for consumers. The civil money penalties are slightly down, and I'm not going to walk everyone through all of the next slides, but we'll flip to them and just talk about some recent enforcement actions to give you a flavor of them. The CFPB, and I do want to note that at the CFPB, some of these enforcement actions were likely a product of the previous administration. It takes months, if not years, sometimes to move things forward. So some of these enforcement actions can be impugned to the current director, and some have to go to Rich Cordray just by that nature. There are some what I would call sort of low-hanging fruit, technical violations. Violating the Electronic Funds Transfer Act, violating the Truth in Lending Act's ability or annual percentage rate disclosures or other natures. Those are pretty easy for any regulatory agency to cite as a violation. What you're seeing now when you look through many of these enforcement actions are that the civil money penalties appear to be much more reasonable. They are smaller. Look, you have to take out sort of the extremes on both ends when you're looking at sort of finding the middle ground. The dollar civil money penalties generally indicate that someone had an inability to pay, and so the CFPB, or any regulator for that matter, the Federal Trade Commission does it the same, will settle for a smaller amount or have an avalanche clause with a suspended sentence, or suspended ability to pay. And so you'll see some of that, but what the trends do seem to indicate is that large banks are being hit for technical violations in many instances. The non-banks, if you're a small dollar lender or any kind of lender and you're doing anything related to service members, that seems to be a very hot topic, as it rightfully should be. We should protect our service members when they're serving our country. They should not be susceptible or to being taken advantage of or allowed to be taken advantage of. So I don't think you'll see much pushback on that. And so these two slides and the next one just indicate some of what the CFPB has done more recently. And again, when you look at the different areas, you'll see mortgage, which is the largest credit market in the country. You'll see student lending, which is another significant market in the country. You'll see some small dollar lending. I haven't seen too much in the scope of credit card or auto finance yet, but those again are significant marketplaces. The CFPB has also, I guess, most notable in the first 6 months of 2019, have filed a couple of suits. And one is against a debt collection law firm. That's fascinating to me because that is continuing on sort of the theme of meaningful attorney involvement in debt collection. And then the other case, and also that comes at a time when the CFPB has an active rulemaking underway for debt collection. And then the second case was a credit repair company, and so generally related to telemarketing sales rule violations and other UDAP. So it will be interesting to see where those play out, and it'll be interesting to see whether those are settled or go all the way through, let's say, summary judgment or a trial of some type.
So I found the fact that 2 lawsuits have been filed to be interesting because generally speaking, so under Rich Cordray, lawsuits were filed much more frequently, I think, and there was a sense that the Bureau enforcement office was staffed up with people who were kind of interested in going to court and going into litigation. And there's a sense that maybe those same people, some of them at least, are still at the Bureau, but that there's less of an appetite for litigation in enforcement. But yet we see 2, relatively non-inconsequential lawsuits that were filed pretty recently, and there's no indication that those parties are walking away so quickly. I mean, generally lawsuits at the Bureau don't get filed unless all settlement discussions have broken down.
I think that's right. Just to put it in perspective, I think during the same time frame, under Rich Cordray, there were 8 to 10 lawsuits filed, and we have 2 lawsuits filed now. One thing Director Kraninger did note has noted in a number of speeches is that you have to use the government resources efficiently that you have, and litigation does take up a lot more government resources, and you can do, generally speaking, sometimes you can do less with litigation and more with rulemaking across entire marketplaces. So this may be a movement to make it clear that there are certain instances where where the CFPB doesn't have rulemaking, or they're changing the rules, and so enforcement might be necessary.
I think also, at least in the last regime under Cordray, there was an appetite for risk-taking that I don't know, it's too soon to tell if the appetite is still there in this enforcement office. Common received wisdom says no. I'm not sure I believe that. I think there is an appetite for risk-taking. I just don't think it's quite as high as it was. The tolerance is quite as high as it was under Cordray. But there was, in Rich Cordray's regime, a real appetite for risk-taking in the litigation realm, and this thought was, look, we may not win every lawsuit we bring, but we're going to bring lawsuits if and when we think they're acceptable and needed. And that is a marked departure from a lot of other enforcement agencies like the CFPB. You don't see, the FTC, you see a lot of litigation, but historically you don't see prudential regulators, the banking regulators, running into court or even initiating administrative proceedings quite like the Bureau was initiating district court proceedings. And I think it's all very interesting to see how this shakes out and telling, what the appetite is for risk, because obviously when you go into court, the certainty isn't really a given, and the Bureau has lost. They've lost some really important arguments. They've lost some really important cases. They've lost some really important appellate decisions because they were not willing to settle or go home and go away like the party that they were litigating against wanted them to. And it's hard to tell here how that all shakes out.
It will also be interesting to see if more enforcement activity comes as a product or a consequence of supervisory activity.
Yep.
So if the new director in the current Bureau shifts more from a model of taking some supervisory referrals and letting enforcement sort of be independent and investigate and open and litigate on its own versus what the prudential banking regulators tend to do, which is every litigation, usually administrative, is a referral from the supervisory arm. And so we may begin to see a lot more of supervisory referrals, or that may be sort of the roadblock that slows things down. Another thing that is interesting to point out is, Rich Cordray started as the head of the enforcement office, and then sort of people that he knew very well or worked with closely took over. Now we're on the third or fourth director of the enforcement office, and there's an acting enforcement director in place, and an acting enforcement director who had been at the Bureau from the get-go, from the start of it, who has not been brought in from the current administration. So, I question how much enforcement activity we really will see. But I do think if you're a business and you have either a technical violation or a UDAP that's pretty clear, and you're taking advantage of service members, you're going to get dinged for that.
Yep.
And again, as I said, rightfully so. And I think certain products of large banks, for example, any large bank opening up accounts that without authorization or taking action or not responding to consumer authorization, that may be low-hanging fruit in today's political environment. So that is generally where we are with enforcement trends. I do want to note that we have seen here at Venable a number of civil investigative demands come out of the Bureau in the past 2 or 3 months.
Yeah, we've seen a real spike.
So it is not that, and it is not that they aren't taking action. And one thing to consider would be where the Bureau will be 6 months to 12 months from now, because during Acting Director Mulvaney's tenure, it was very clear that CFPB the Enforcement Office had a very small leash or ability to do anything. And so when CIDs are not flowing out of the office, you don't have that sort of cyclical nature of, someone's working on CIDs, someone's in litigation, someone's in settlement, and it's the well is replenishing, so to speak. And so now to replenish the enforcement activity well, it will take a little while, and as I mentioned, we're seeing CIDs start flowing again. So there will be some enforcement activity. I don't believe that it will reach Rich Cordray's sort of appetite for enforcement. I don't think that we will see, in any 6-month given period, a 22 enforcement actions as you did during Rich Cordray, or more than that. I think it will probably stay under somewhere half a dozen to a dozen.
So, yeah, I agree with all of these trends, and I think the forecasting, and obviously it's just a forecast, a few notes, and then I want to talk a little bit about the notification of purpose change-up in the civil investigative demand process. And so the current acting enforcement director is Kara Peterson, who is somebody that started at the Bureau at the very beginning. She came from the Federal Trade Commission. She's definitely an enforcement lawyer by instinct and habit of the mind, and I suspect she will drive pretty hard to get enforcement actions brought. It's hard to know the interplay between her and folks in the front office, Kraniger's administration, but if Kara, I think, has her way, I think you will see an uptick in enforcement action. She is a very formidable enforcement person, and somebody Jerry and I know very well from our days at the Bureau, and also somebody who kind of inherited the Federal Trade Commission's instincts, which means maybe a little more cautious than the Rich Cordray regime, but a little bit more aggressive than maybe what you would expect out of this current regime. So it'll be interesting to see. So one of the more significant developments that we've seen recently come out of the CFPB has to do with it changing its policy relating to what's called a notification of purpose. So the notification of purpose is the part of the civil investigative demand that tells the recipient of the CID what the investigation is about. And specifically in April of this year, the Bureau announced that it was going to be changing its policy to really conform to 2 relatively recent appellate decisions and also an Inspector General's report that suggested that the Bureau should do this. And I want to tee up this issue a little bit more precisely. So historically, the Bureau's view of its notification of purpose was that it really didn't have to do a lot or give a lot of notice to recipients about what it was looking at or investigating. And I would argue that the new notification of purpose doesn't give a ton of notice either, but it gives a lot more notice than the prior version. Previously, you could get a CID that basically said, we're looking at violations of the consumer finance laws, which of course doesn't really tell you a lot if you receive it and you're a consumer finance company. It's not really clear what they're looking at, and that could be particularly disconcerting to a business that gets one of these and has a relatively small number of resources to devote to responding. And so there were a number of challenges to it, one of which, of course, my team and our firm handled the first challenge, which was the CFPB versus ACICS, ultimately ruled on by the D.C. Circuit in April of 2017, essentially the first time that an administrative subpoena had been overturned in about 50 years. But really what the D.C. Circuit said is, look, guys, if you're going to issue these, you really have to have notifications of purpose that are quite a bit more precise and contoured than what you've been doing. And of course, the Fifth Circuit subsequently in 2018 in CFPB versus public data, Source for Public Data, upheld that as well. So then you have 2, circuits basically saying the same thing, which is, look, these types of notifications of purpose that are more vague, that are more generic, that fail to give really good notice of what conduct is at issue potentially, they're infirm under the language of the Consumer Financial Protection Act. They need to be redone. And then, of course, the Inspector General, the Office of Inspector General of the Federal Reserve, which is the OIG that oversees the CFPB as well, issued a statement in 2017 also enunciating this concern. So finally, in April of 19, 2 years after the ACICS decision, you see the Bureau formally announce that it's basically going to require, on a go-forward, that its enforcement office issue CIDs with more contoured, precise notification of purpose language, which I think in the main is a really good thing for the industry. I think it's a really good thing for stakeholders of all different aspects of being a stakeholder, whether you're a consumer advocate, you're an industry advocate, you're a government lawyer defending a CID. It's always easier to know what you're looking at than not know what you're looking at, regardless of where you sit in that chain. And I think in the main it's probably better, too, because what you have is a much more narrowed focus, at least at the outset. So a company gets a CID, and in theory they at least have more instinct or more understanding of what it is that's being looked at. And I think that in the main that's probably a good thing. Now, a couple of things that make it harder maybe. It used to be that when you would get a notification of purpose that was so broad, you could say, well, gee, this is so broad that now I can challenge the CID because I don't even know what you're talking about or looking at. Especially after the D.C. Circuit decision, there were a number of companies and entities that did that, some of which were successful, some of which were not. Obviously, that's not necessarily the same avenue it once was. But having said that, I still think you're better off knowing what's being looked at than not knowing what's being looked at. It's a lot less burdensome to respond to something that's not as open-ended. It helps companies that receive CIDs mitigate risk going forward. It can result ultimately into improved processes, both in terms of the company's process, but also the Bureau's process. And one of the things that we spend a lot of time on our team thinking about is notifications of purpose. And Aaron and I, in particular, talk about this issue with some frequency. And Aaron, I'm curious, you've had CIDs that you've dealt with that were April 19 policy change and post-April 19 policy change. In fact, we're handling some right now. What are your thoughts about some of the changes you've seen in terms of responsiveness, but also is it easier, is it harder to manage?
I think it's easier to manage. I think in terms of assessing, what documents you need to identify, collect, from a logistics standpoint, it's certainly easier to manage. I also think, in terms of how does that affect your business going forward, your client's business going forward, what's the liability, what's the scope, what's the exposure there. I think the more that you know what they're looking at and the way that you are responding to the request, I think that's a lot easier. I also think it's easier to think about, if you know what they're asking, you can even narrow it further sometimes. And if it's so broad, you just sometimes don't even know where to start.
It just seems like it's also fair. That you're on notice of what's being investigated. I can tell you I've had at least one client who had a notification of purpose that said, in the past, that said the CFPB was investigating a law that was inapplicable to their entire business. That literally did not apply. So they had no idea, among other things, how this could even help them or be a valid notification of purpose. So.
I think that's right, and that was certainly the experience of a number of companies, and some of which challenged the notification of purpose and prevailed in court on those exact arguments, which is, I don't even know what you're talking about here because nothing I do falls within the obvious scope of the CFPA or the statutes the Bureau enforces. I also think from a perspective of the Bureau, I think it's easier to defend your practices in the enforcement world and from a policy perspective to critics. If you say, look, we're issuing civil investigative demands that are narrow enough for parties to feel like they're getting a fair shake, that they're on notice, that they're able to mitigate risk, that they're able to understand risk and maybe correct a problem before it gets worse. But also, it makes it easier to manage that investigation because you kind of have a sense of where it begins and ends. I should note, though, that just because you get a CID that fits the new April 19th policy, that doesn't mean you don't get a second CID that also has another notification of purpose that maybe is a little different. So one of the things the Bureau would say in response to these notification of purpose arguments that used to be made is, well, we're just trying to get away with serving you with one CID. So now they have to serve you sometimes with 1 or 2 or 3 CIDs. So, again, these things always cut both ways. But having said that, I think in the main you're still better off getting something that's narrower, easier to respond to, easier to understand, easier to try to mitigate on the back end, to manage risk, to help your clients manage risk, to help your companies manage risk, which at the end of the day, of course, is what this is all about. So I think in the main, it's definitely a good thing that this has happened, and obviously the Bureau's responsiveness to it is also very telling, because it really did take 2 years from the D.C. Circuit decision and the OIG report for the CFPB to say, look, we hear you guys. We're gonna change our policy to reflect what the national law is now and what the recommendations from our own Inspector General say, which I think is also telling a little bit about what you're seeing on the ground from the Kraniger regime, which is maybe more of an instinct to be responsive and to be a little more transparent to stakeholders. So one of the things that kind of dovetails well, though, in our thinking here, one of the received pieces of wisdom that we got in January 17 after Trump was inaugurated was that somehow the Bureau was going to go to sleep and all consumer financial protection activity in the enforcement world was going to stop. And there was a concern about that, certainly at the state AG level. And as we know, that hasn't happened. Number one, the Bureau continues to be active, per Jerry's discussion. Number two, the state AGs have been increasingly active since January 17. And you in particular, Meredith, kind of have a front row seat to this activity. And I'm hoping you can walk us through some of what you've seen on the ground and how that meshes with the Bureau's current regime and kind of how you forecast the state enforcement activity going forward.
Sure. Thanks very much. You'll see from the slides, I've looked back about 6 months in 2019 just to see what the current trends are, what kind of enforcement actions the AGs have been pursuing that we know of. And one thing that I thought was interesting in looking at the AAG activity was, in addition to enforcement actions, there have been a lot of AG initiatives to raise comments and concerns with some of the federal agencies. We'll walk through these slides, but as an overview, you'll see the issues are very similar to the issues that Jerry indicated that the CFPB is interested in generally: lending, servicing, for-profit schools, veterans. But I think more fundamentally, the recent Attorney General activity suggests that they're suffering from a bit of an existential concern, and that's their ability to carry out their enforcement activities and their enforcement priorities in the wake of what they see as some federal policies that are interfering or potentially interfering with their ability to enforce their various state laws. And again, we'll walk through the individual bullet points here, but just as a broad overview, for the AGs, they've contacted the Department of Justice to raise concerns about student loan servicing, and particularly or specifically federal student loan servicing. And there's been a spate of litigation and policy positions taken on preemption and whether federal agencies and the federal government has the final say on how federal student loans should be serviced, or whether there is room for state enforcement in that realm. And there's also been some skirmishes between the AGs and the Department of Education on the AG's ability to receive information from the Department of Education about federal student loans. Apparently the department has clawed back or clammed up on the type of information it will give to states. And with respect to the CFPB, you'll see that the state attorneys general have contacted or commented on the CFPB's proposed rollback of small dollar loan ability to repay rules. And although they have a host of comments and criticisms about that proposition, the AGs are especially concerned with the absence of a federal floor around this industry and fear that it will lead to lenders finding loopholes around state laws. They also have indicated that they share a similar concern with respect to the CFPB's proposed no-action letter rules and sandbox policy. They have expressed some concern that this will, specifically the sandbox, will immunize immunize financial services providers from state liability. So we can go back to the beginning, back to June. We're going to work backwards through some recent developments. The first bullet point on the list is a very recent $168 million settlement. This actually plays a part in what Jerry was talking about earlier. It's a settlement regarding a for-profit school and temporary loans that were then converted into high-interest loans. And it's contingent upon the approval of the CFPB settlement as well. So that's a pretty big multi-state, 43 states. You've got your blues and your red states all coming together on this settlement involving for-profit debt. And that's going to affect 19,000 student loan borrowers. I believe that the states are jockeying for how much of the pie each of the states gets for their individual state constituents. The second bullet point is one of these policy pieces. There was recent testimony provided before the House Financial Services Committee on student loan servicing, and this testimony involved, I think, representatives from three state attorney general offices, and some of the servicing failures that they criticized involved servicers not providing borrowers with information about income-based or income-driven repayment plans, and the AGs argue that the failure of servicers to provide complete and correct information has led to the rise of debt relief companies, which, according to the AGs, are preying on borrowers who are suffering from defaulted loans. And then another issue that was identified in this testimony was something called forbearance steering, where the AGs allege that schools, because they want to maintain their cohort numbers, meaning that they want to show that their students are not defaulting, because a high default rate among different universities would suggest that students are having trouble finding and keeping their jobs, that they are working with servicers or consultants to steer borrowers into forbearance, again, rather than, I suppose, using income-based repayment plans, but that in any event that this forbearance steering is masking default rates and also ultimately harming borrowers because it's causing them to incur additional interest and causing them to owe more on their loans than they otherwise would. The third bullet point is, again, you've got all the states and territories that were part of this initiative asking the Department of Education to automatically forgive the student loans of permanently disabled veterans. Their position is that under the law, permanently disabled veterans are automatically entitled to have their student loans discharged. And although the department knows that, they are requiring the veterans to jump through administrative loopholes that are not legally required. And so this position was that the veterans should get their loans discharged. They put out these numbers. I don't know if they're correct, but 42,000 vets are eligible. Only 9,000 had applied, and 25,000 were in default. So if that initiative is received by the department and affected, it would be have quite an impact on the veterans that are certainly default.
So Meredith, one of the things that your slides, your bullet points here highlight is the role that the states in particular are playing in the education world, in the servicing world, and or the debt forgiveness world or forbearance world. Do you have an understanding of, you think that they're playing that role in a heightened way since January of 17, or is this kind of the natural progression that would have flown out of any regime, regardless of who the president is or who the administration is controlling the CFPB?
I think they have a natural interest in this subject. I think it's an easy cause to get behind to protect students, and particularly, students who are also veterans. However, I do believe that the back and forth you see with the Department of Education and with the CFPB is a byproduct of the new administration, and rules that have been implemented or that may be de-implemented that the Attorney General contingents believe should not be weakened in order to weaken not only federal oversight but also impact their ability to enforce their state laws. I think, if it was just federal, if it was just only affecting the federal government, they may have taken a quieter stance, but because they perceive these various CFPB and Department of Education policies as negatively affecting their ability to enforce the laws that they're entitled to enforce, they're taking a very strong stance against it. If we want to go to the next slide, these are more, for the most part on these slides, you'll see these are more traditional enforcement actions that the different state attorneys general are bringing. Maura Healey in Massachusetts has filed several assurances of discontinuance, not only in this year, but going back into 2018 involving mortgage servicing. There's a rule in Maryland, or a law in Massachusetts called the Act Against Unlawful and Unnecessary Foreclosures. It's known as 35B, and it applies to subprime loans and the ability to get modifications of subprime loans. And so she's taken a pretty activist role in enforcing 35B, and you'll see that the news reporting around these assurances of discontinuance also pull in additional issues that sort of stem from these 35B investigations, including one of the recent settlements involved sort of a tisk-tisking about interest-only modifications, and just generally having some poor communication skills with borrowers who are looking for modification.
I'm struck by the first bullet where it's 2003 to 2007, Attorney General Becerra, who's a very intelligent and very aggressive state AG in California. I mean, that's, the end of that is 12 years ago.
Yeah,
for RMBS, that's the residential mortgage-backed securities cases that we're still seeing. What's going on with that?
I was struck by that as well. It seems like it's the gift that just keeps on giving,
yeah,
going back to the securitization from the 2008 crash. I think they're wrapping it up, although, again, you see these come out in dribs and drabs as well. But also, I think that the RMBS and securitization issues going back to that time frame also inform some of the decisions that are being made today. I think a lot of the AGs see the student lending and small dollar lending as the next crisis waiting to happen.
And the RMBS stuff was really more the Department of Justice than the CFPB. The Financial Fraud Enforcement Task Force focused a lot on that, and that I don't even think that that's particularly active anymore. It's mostly been disbanded, but the CFPB did a little in mortgage servicing, but not so much in the securitization world. So that's fascinating that Becerra, a mere 2 months ago, was getting a settlement for RMBS that goes back 12 years. That's very telling about the reach of these state AGs and kind of where they see themselves sitting in the consumer finance enforcement space. And you're right, I think that student loans are really the next big wave for them, and they have been for the last, 5 years or so.
Yeah, and the April 5th, the Delaware-Massachusetts settlement, that involves subprime auto lending, which the press release from the AG, I believe in Delaware, indicated that investigation arose out of an investigation into securitization of subprime auto loans. So clearly they're looking at these large, institutionalized lending programs that have broader economic impacts as well. And then on the final slide, you'll see this references the regulatory sandbox criticism, and one of the issues that the AGs are taking up with the CFPB here is that they're concerned that the Bureau is sort of caving into industry desires to innovate without taking into consideration the protection of the consumers. And they seem to be saying that innovation and the Bureau's support of it is going to end up allowing companies to evade the law, whereas the states would favor a more cautious and deliberative approach to these new technologies. And one thing that they identified in their comments to the Bureau was a complaint that under the Bureau's current no action letter policy. And this letter deals with both the no action letters and the regulatory sandbox. The Bureau has previously exercised that no action letter process very sparingly, and the indication was that they would not use it to weigh in on UDEP violations, whereas the current or proposal does suggest that they'll weigh in and issue no action letters on UDEP issues.
So Jerry, this is an area you've also spent some time in, but maybe more from the CFPB perspective. Why do you think the state AGs care about this regulatory sandbox issue and the expansion of the no action letter policy that the Bureau started with really its initial entree into this Project Catalyst and kind of its initial entree into innovation?
I think the initial Project Catalyst and the no action letters were issued very seldomly, not because there were a lack of people that wanted them. I think the process itself was being developed at the CFPB, which was quite laborious because every different part of the CFPB wanted to opine to every company's aspect of a no action letter. So I think that the process itself was just not developed. The second problem that the CFPB had in the past was that any business applying for no action letter basically had to submit all of the proprietary business information and hope that the CFPB would keep it private. There was no guarantee. And so I think that there were some substantial barriers there. What I find interesting is that some of the companies seeking to use the regulatory sandbox are not necessarily seeking to take advantage of consumers, but are seeking to take advantage of new products in the marketplace to innovate to help consumers. And so I understand the state AG's concerns on one end, but on the other end, there is actually no proof that companies have misused the regulatory sandbox to commit consumer harm or that there is consumer harm. So it's very interesting to me, the interplay of the state AGs who want better consumer protection and better consumer access to credit, for example, but at the same time want to drastically limit any guarantees or protections to those who will innovate. And when you think back to one of the to significant market interrupters, a lot of them developed because of an intersection of where business and the law didn't quite meet, and the law, as everyone knows, doesn't keep up with innovation. It's nearly impossible. Congress can't move that quickly, ever. And so, it will be interesting to see what happens if more no action letters are issued, how that will impact new products being developed and the flow of credit to consumers or of other consumer financial services products and services, because I don't think anyone could legitimately say right now that there is sort of a hampering of credit in the marketplace. There is a lot of credit there now, and so as things move forward in the future, it will just be, how can products develop better or within the sandbox. Of course, the state AG's favorite lines that I hear are that, sandboxes are for children, or things of that nature. And you know what? I think every innovator at heart is a child. So I'm not sure how the sandboxes will play out. But we right? But we shall see.
So I'm also struck by another bullet point here, Meredith, that concerns the Department of Financial Services and its interconnection with the New York AG. The New York DFS and the New York AG. Can you talk a bit about what you're seeing there? The Department of Financial Services, of course, has recently announced it's consolidating some of its enforcement power into one unit that's run by a former Southern District of New York prosecutor. There's all expectations that it will become an even more aggressive source of enforcing the consumer finance laws. What are your thoughts about that and how it plays with the New York AG?
Yeah, it's very interesting, and I think to date we have seen, and maybe to the frustration of some of our clients, parallel DFS and New York AG investigations, and maybe not entirely consistent approaches, and the perception that one of the agencies may be taking a stronger position than the other. So the fact that they are working in tandem here, I can see the pros and cons of that. I mean, I think it's preferable to perhaps have one stream of investigation from a state But at the same time, to the extent that DFS may have been perceived as a bigger threat to consumer financial services providers, and I don't know that perception is correct, but I think that perception did exist. If they're now piggybacking, or the AGs are piggybacking on them, I think that could be a potentially troubling dynamic.
Yeah, I share that view. The New York AG is historically a fairly aggressive office, especially in the consumer financial services space, and historically the Department of Financial Services, which of course is also the licensing unit in New York for financial services companies, banks and non-banks alike. The fact that the DFS, which is the licensing entity, is also ascribing to much more aggressive enforcement tactics, if you will, that's a very disconcerting development, I think, because you could see a real confluence of a lot of state-based power coming out of New York, and in light of what the CFPB is doing now and kind of ramping itself back up, I'm not sure that the folks in New York are really stepping into a vacuum as much as kind of building out and acting with more momentum. So it's definitely a development we're following pretty carefully, and that January of 2019 settlement, which was more than 6 months ago, just jumped out at me because that was shortly after the new Attorney General, Tish James, had been elected, and the DFS hadn't even announced its special unit. So more to come, I think, right?
Mm-hmm.
And speaking of more to come, one thing to note is there are a significant number of former CFPB attorneys who are now in state attorney general's offices. You have California, Illinois, New York, Pennsylvania, and probably some states that I'm missing.
So, and the DBO in California?
Exactly right. So you have state attorney general's offices, you have financial regulators, all with former CFPBs now either at the helm or in significant roles. So state AGs, never to be underestimated.
Yeah, I think that's right. And they're definitely taking a page from the enforcement book, but adding to it. One of the things that's also interesting is as we talk about the Consumer Financial Protection Act, whatever the Bureau does with its abusive doctrine, the states, of course, can use the CFPA and bring a cause of action under the CFPA as well and build that doctrine out. So even if the Bureau recedes and takes a step back and says we're not going to use abusive or we're going to be more circumspect in how we define deception and unfairness, there's nothing really to stop the states from being more aggressive and kind of, building out that doctrine even more aggressively than the CFPB might, and in fact, the CFPA was written for that purpose, and it was contemplated that at one point or another you might have that kind of back and forth between the states and the Fed. So it's an interesting time that we're living in right now. One of the things that I want to switch topics a bit because I think that as we talk about trends in enforcement, it's important to have a plan in place if you get one of these subpoenas or civil investigative demands from either the Consumer Financial Protection Bureau, or you get one from the state AG, or you get an inquiry from the Department of Business Organizations in California or the Department of Financial Services in New York, to name two. How do you respond, and what are some of the best practices right out of the gate? And Erin and Liz, I'm hoping that you can help us unwind some of these issues and give us some steps forward just to think about in the event that folks on this call find themselves in the unfortunate place of getting one of these CIDs or subpoenas. And Erin, if you want to start us off.
Sure. So I think, regardless of where it's coming from, if you get a CID or a subpoena, one of the first things that you want to think about is issuing a litigation hold to preserve documents, preserve materials. And this is definitely something that I think you want to think broadly about, whether you ultimately end up producing documents or, a fight over whether they may or may not be responsive is a question for down the road. But initially, I think you just want to make sure that you're preserving documents and other materials so that you're not ultimately in a fight about spoliation. And so thinking about what a litigation hold might look like, who it might go to, where the information that's contemplated by the request might be kept, including, if there are automatic deletion processes that you have in place, or a lot of times we'll see people or companies that use templates that might get they're active templates that get written over, things like that. You want to think about how to keep those in place at the time you receive the request. And I think also thinking about, are there employees who have left? You may ultimately need to revise or reissue a litigation hold that you send out if you have new employees that are coming in, but also if you have another CID or subpoena that follows up on the first one, or if some of the requests are modified. And then one other point on here is, the different types of information that could be responsive, which, email's a big one. If there's databases, other kinds of electronic information that might not be sort of the first thing that you think about, but certainly could have a lot of responsive information there as well.
I find that people often overlook, text messages on work issued devices or services like Slack or other things, that instant messaging services. So, are those things that anyone who receives a CID should also be considering?
Definitely something to think about, and I think that it's something that's still developing, and a lot of people, some companies might use different formats that the agency that you're working with may not have in mind as they're writing it, but a lot of times. It's still an obligation to preserve that. And so it's definitely something you want to think about and talk through with your attorneys and talk through with maybe an IT person at your company. I think the next thing you want to do is really look closely at what the requests are and the statement of purpose too, to the extent that there's one in there. I think looking at what would be contemplated by a litigation hold, but also by responding to the requests and beginning to collect the information that you would ultimately be producing. To think about what the requests are asking for, but specifically how are terms defined in there. They may be defined in a way that's not necessarily how you would use them. And it's a good opportunity to sort of, I think, start a conversation about is there a way we would go back to the agency and ask to narrow or clarify the requests themselves. Maybe it's not. Maybe it's defined. Maybe there are terms that are defined in ways that you wouldn't use them, or there's a request for information that doesn't really fit with what you do or how information is kept in the ordinary course of business. So I think looking carefully at the requests, at the definitions, and then also thinking about what are the requests that are really burdensome that would just be very difficult to respond to, and maybe there's a way to think about respond initially with a smaller sample of documents or narrowing the time frame for certain requests, and this is all sort of part of a back and forth that you would ultimately have with the requesting agency, but it's helpful just, especially initially, thinking about what are the challenges that you would face in responding to requests as written.
What's interesting is when you talk, Aaron, about the burdens, the Federal Trade Commission has a general standing practice that they won't give you a CID extension unless you produce something on the initial due date. Yep. Now, the CFPB hasn't taken that tack, but they seem to look more favorably on it. So, to your point, I think it's really important to look at the data, the documents, information you have, and decide, is this something I can get right away? Are these requests too burdensome? Can we narrow them and get a small tranche of it and then supplement? So, all really great suggestions.
I think that also helps to build a rapport with whoever you're speaking with, to show that you're, cooperating to the extent that you can, which may build up some goodwill, when you're talking about requests you may be more concerned about, producing information too.
How receptive have you found the Bureau to be, to Jerry's point, if you kind of do that? You say, look, we'll produce these 5 things, it's not a lift, and here you go, but these 3 things are big lifts. What has been your experience with that?
I think that they tend to be pretty receptive to that. I think it depends on what the request is, and that's sometimes a good way to sort of gauge what they're really focused on and what they're interested in. But I think that's why, you sometimes have to think about what's the fight worth having here, and that it may be more worth it to fight about certain things that are more difficult to get, but may not be as, may not give you as much exposure as opposed to other requests that, you may want to think more about. So I think weigh priorities too. And then just this last slide, thinking about different things you want to think about as you're continuing to identify and collect documents. Privilege is something we talk about a lot, and this goes back again to thinking about holding on to information, collecting information, and then giving it, whether you're going to produce it or not. I think when it comes to privilege, you want to think about, again, who's going to have that information, and it can be helpful to have a list of firms or attorneys or issues that you've worked on before that might raise those concerns, so that the people who are looking at documents know that ahead of time. I think, again, this just because you're identifying these documents or talking about them doesn't mean that they're going to be turned over, but all helpful in ultimately compiling a privilege log, which pretty much all CIDs or subpoenas are going to ask for. Confidentiality agreements, I think, some state AGs or agencies may be more open to those than others, but it's certainly something that's good to think about, and if there are particular confidentiality concerns, those are good to think about early on.
Now, one of the practices that we talk about in our team is whether you need a confidentiality agreement for the Consumer Financial Protection Bureau or Federal Trade Commission, because they have rules that govern that. So I don't know if you can talk a bit about how those rules stack up against the kind of protections you get from a confidentiality agreement with, say, a multi-state state AG investigation.
Right, and that's why I think it's worth thinking about who you're asking it of. It may not be as necessary when you're talking about the FTC or the CFPB. If you're talking about a multi-state investigation where that information might be governed by a lot of different state laws, and that might be something you're more focused on. Ultimately, whether it's an ask you want to make, I think again goes back to how much you want to. This is a fight you want to have. If you're not really concerned it's going to be distributed ultimately, then it might not be something that you want to spend a lot of capital on. And then I think just finally thinking about third-party concerns. If any of the requests contemplate producing information that you've gotten from a third party, is that governed by a contract you need to look at to see if you need to notify them before you produce or at any point. So just something else to think about in terms of producing in general, but also specifically with respect to confidentiality issues.
So Erin's kind of walked us through best practices on the ground when you get a CID, what you do in-house to make sure you've, preserved your documents, addressed confidentiality issues, privilege issues, had a conversation back and forth with the agency that's sending you the CID. But what about the actual mechanics of responding to the CID? Liz, if you can give us some thoughts on that, and kind of best practices from your perspective in handling those types of things, both from the CFPB perspective, state AG perspective, et cetera.
Sure, thank you. So I came out a little aggressive in my slides and just assumed that you were going to challenge the CID. That may not be the case. You may look at the CID, it may be well drafted, it may be narrow, and as Erin has hinted, you may decide that this isn't a fight worth having, and it would be better just to cooperate with the agency, possibly get them to make some concessions, to make some agreements with you. If all that breaks down and fails, then you have the option of challenging the CID, and the mechanism for that is a petition to set aside or quash. As Allison brought up, there is a change going on in the way that CIDs are drafted that may make it more difficult to challenge them on the basis of vagueness and broadness. However, they can still be attacked on the basis of lacking jurisdiction. So the only reason that an agency has the right to demand these documents from you is it's authorized in statute. If the CID goes outside of the statute, then it can be challenged on that ground and can be set aside. So, in general, the petition should emphasize the agency's authority and that it's limited to the authorized in statute, and then challenge the parts of the CID that you think exceed the agency's jurisdiction. So, you should include a copy of the CID. You can also include other declarations or documents, anything that you feel explains your argument. As Jerry mentioned, there have been instances of CIDs that are after employers or companies that are in no way covered by the CFPB's jurisdiction, and so that's something that you want to explain to the agency, assuming that your attempts to explain it to them prior to filing this petition have failed. And then the mechanics of it are very easy. It's filed through email with the Office of the Executive Secretary. So you just PDF it and send it along. You want to also request confidentiality. Absent a request, the petition will be public, and it's likely that there's going to be commercially sensitive information in the petition. There are many reasons why it should be confidential. The investigation usually isn't public. There is a risk if the investigation is made public of harm to the target of the investigation. And usually at this stage in the investigation, the public doesn't have much of a benefit or much of a need to know about where the investigation is. You're not guaranteed that this will be successful, and so as a good general practice, you should submit a redacted version and request first that the agency give you notice before publishing it, and that they publish the redacted version instead.
So one of the things about this request for confidentiality, and this is particular to the Consumer Financial Protection Bureau's petition to modify or quash, is it almost never is the case, right, that they grant your motion for confidentiality. It almost always is published on their website. Even if you redact it, that's great. You redact out the sensitive stuff, and they'll respect that redaction. So they won't publish deliberately sensitive information if you designate it that way. But the fact of the investigation becomes public more often than not when you go this route. And so, Liz, I wonder how you think about that, because on one hand, you definitely want to be on record of seeking modifications, especially if you're going to then pursue it in court and or not respond. You kind of want to have that as a prophylactic. But on the other hand, the fact of the investigation, to your point, becomes public, right, and some of the risk associated with that from an investor perspective, from a client relationship perspective, meaning your clients' clients, business relationships, consumer-facing relationships become compromised potentially. How do you address that? How do you think about that?
So I think it's important to note that the challenge in the CID is not a quick fix for this problem. This is going to have a cloud hanging over for a while because they do not resolve these quickly. So in addition to the fact that this will likely then make it public, you're going to have it hanging over your head for a while. And that's part of the strategy when you decide whether you want to challenge or whether you want to respond or work with the agency to narrow the request. I would also make sure that your redactions are as liberal as you can make them. You know, if you think not only your own company's name, but if there are other companies that you're mentioning, just get rid of all of it and make it broad, and then take a proactive measures beforehand. So you're requesting notice, you know it's going to be published, the agency's going to tell you, so it's important to get out there and get in front of it, as far as I'm concerned. That if you know you've done nothing wrong, if you think your argument is strong, that this is outside jurisdiction, that there's just no basis for it, then the minute the agency gives you notice, I say get out in front of it.
And if you were going to go into court, for example, and challenge the CID, or not respond and make the Bureau challenge you, that having gone through this administrative process, I think, is a requirement, isn't it?
I believe so, yes. If you're going to challenge it in court, and certainly if you want the agency to bring an action in court, you're going to need to do this as well. And
Erin and I have actually litigated this exact issue, and that was your experience as well, that you had to file this administratively first, right?
Right.
Yeah.
And you may not really expect that they're going to change their mind. If as Liz mentioned, if you weren't able to convince them before you filed this, there may not be a great chance they're going to change their mind, but you don't want to waive anything in the meantime.
Right.
Well, and I also think it's important because, like you said, this is likely going to become public. Get your narrative out there then. Like in your petition, you can tell your side of the story and get it out there rather than just staying quiet and letting the agency come after you.
One of the issues that I think has kind of plagued this world is it considered to be a taint if you're investigated by the CFPB? And at the outset of the Bureau's life, it was, but increasingly so many companies have been, that I think a lot of that taint has been reduced, which is part of the thinking in how you think about confidentiality here, it sounds like.
No, I agree. I think that they've done a great service in investigating a lot of people because it's taken the stigma about it away. So finally, if you do end up responding, either because your petition is denied and you choose not to challenge it in court, or you just decide, I want to get this over with, I want to get it done, you're going to want to review the documents before you produce them. This is very similar to a typical production based in a private civil litigation. Look for whether they're responsive. So certainly look at the issues. Look at what the agency is actually asking for. Look for privilege. Look for conscious confidentiality, everything that Erin covered. And then typically you're going to upload them to a file sharing site. This will all be detailed in the CID. And so if you're working with a third-party vendor or if you have an in-house IT group that's handling that for you, they can coordinate to make sure that is done seamlessly. And then if you feel like you need time, I would highly encourage you to communicate with the agency before you run out of time. And then as a best practice, you're going to want to document all your productions and then back up the productions internally so that you have a record what you gave to the agency.
So one of the things we do when we do these document productions, and Meredith and I have this whole protocol in place and can talk a little bit about it, which is, you know, we look at what we're producing from a process perspective, but also from a substance perspective, right, to kind of get an understanding of what's the agency's case against you. You know, they've made all these requests, and sometimes they seem obvious, but sometimes actually when you put all the documents together into some kind of chronological order or you group them a different way, you see a different story emerge. And Meredith, I don't know what, I know you and I have had a lot of experiences with this. I don't know what your thoughts are about that as a practice, but I found it to be very helpful just to know what we're dealing with.
Yeah, I mean, if you have the time, sometimes you're just under a very quick time crunch, and it's difficult to try to piece together a narrative at the same time while you're just trying to get a production out the door. But I think one of the frustrations, even with these enhanced notice provisions, but when you get a CID or a subpoena from an agency, and it'll cite a couple of statutes, and you may have some idea of what they're looking at based on the time frame and the documents they're looking for, but sometimes, you know, we want to try to figure out what do you think we did wrong, and they're not going to tell you, and so you have to reverse engineer your way into where you think they're coming from. And so, you know, to the extent that you're able to, either as you're reviewing the documents or sometime after the first pass, put together a chronology that lays out, you know, the high level or even detailed factual background of the documents that you're producing. I think that it helps you, it helps your client, and to anticipate where they're going, and it also just helps you to, just as Liz was saying, shape the narrative. So you can control, if you don't know what the facts are, it's very difficult to control the narrative as you go forward. And of course, the better handle you have on the facts of the case with that first production, the more strategic you can be as you go forward when you inevitably get follow-up requests and you have follow-up discussions with the agency. And ultimately, when you start talking about potential liability, you really have to understand the facts in order to engage with them meaningfully to negotiate a resolution with the office.
One of the things that, as document productions go, that's sort of becoming the trend and more prevalent are use of either data analytics or machine learning or keyword searching or some type of computer system to help you get through the documents quicker and better. I'd be curious to see what you all think about that, and if you've had any experience with the agencies being receptive to that, to whether it's search terms or, you know, some type of advanced data analytics. You know, machine learning seems to be everywhere. Surely it should be helping attorneys and businesses out.
Erin, Liz in particular, you guys are often on the front lines doing this first. What are your thoughts about that?
So I'm a generally cautious person, and I worry about machine analytics. I worry about what goes out. Often in these investigations, they're very nuanced. They're very, and people are very casual in email. Not everyone says in their, you know, email subject line, and now I'm going to talk about this product. So I do worry about not having a pair of human eyes on every document. That said, there are budgetary constraints, there are time constraints, and certainly if you're very confident that there's nothing, you know, you don't want people to see in the documents, then it probably works out really well. And I'm not even saying, you know, there's something bad. Sometimes there's just stuff that you would prefer to keep private, and whether it's a trade secret or just any sort of, you know, dealing with another company. So that would be my concern, and it would certainly be balanced against the cost of having a human being click through every document.
Yeah, I think you also risk, you know, you have to look at the documents together as a whole, and that's how you sort of figure out what's, not just what's responsive, but what story is this telling, or what's the impression that it's leaving, or, you know, what's not being shown here that you might need to fill in or explain in some other way. You know, an email out of context can certainly do more damage. And maybe it's responsive and you have to produce it anyway, but you certainly want to know about it. And maybe it's that you know you're going to have to produce it, but you still want to look at everything before it actually goes out the door.
Yeah. Computers, analytics, and machine learning as a supplement to the human eye, or in parallel to the human eye, is probably something that's a little more recommendable.
Yeah, I definitely agree with that, especially in the context of a law enforcement investigation where you could have a core component of your business being under scrutiny by the CFPB. And, you know, as great as machines are, humans turn out to know a little bit more still. And I do tend to share Liz and Erin's general skepticism that you can't rely on that alone. You might be able to rely on it for first cuts and second cuts, but we generally have a rule in our group that anything that leaves our office has a set of eyes on it, and it's usually someone pretty senior who has a set of eyes on it before it walks out the door, because we want to know not only are we being responsive, but candidly, what's the story that we're setting ourselves up here to have to defend against? It's really important to understand that as soon as possible. Liz made the really good point of using all of these different ways of shaping your narrative, and I think that that's part of shaping your narrative. So one of the things that I think is interesting to kind of, talk about here, given where we sit, we have a relatively new CFPB director. We have some new attorneys general who've been relatively new, who've been recently elected. We have a changing political landscape, the 2020 election. We've got Elizabeth Warren running for president, the founder of the CFPB. So a lot of the consumer finance issues that we've talked about today are really front and center in the public mind. And I continue to think that those front and center issues shape the way enforcement agencies, particularly agencies where you have elected officials like the state AGs, how they go about prosecuting cases and what cases they even bring. And I'm curious if we could just kind of do a round robin of our panel about what we see next, what trends we see, what are some of the ways that we can respond to those trends. And Meredith, I'm going to start with you.
Sure. So this morning I read that one of the presidential candidates, Mr. Sanders, said that he was going to forgive all student loan debt, private and federal. And so I definitely think this is coming from a place of, people are really keyed up about the cost of education. I know we've internally had a lot of discussions about whether the focus of regulators on servicing is misplaced, and really the focus should be at the more of a policy level of why is education so expensive. But I think that his decision to make that a centerpiece of his platform reflects the greater or broader interest among the country for policing student loans and protecting borrowers from what are perceived to be problematic servicing practices and overly burdensome debt obligations.
And student lending on all of its fronts, originations, collections, servicing, that is probably, if not the biggest consumer finance issue in the near term, certainly among the top 2 or 3. We keep seeing versions of that. And yeah, the public conversation in the more general way is animating that, I think. Erin, what are you seeing in terms of trends and forecasting here with the agencies that you work with?
I think sort of piggybacking on that a little bit, I think there seems to be some information sharing between certainly multi-state investigations that are sort of rallying around these issues that everyone seems to agree on. Focusing on populations that are vulnerable, or populations that everybody can agree should be protected. They're easy issues to get behind, and I think we're going to see more of that.
More of a focus on kind of more politically neutral endeavors, if you will. Right. I mean, I always would say, so the first, the service member, the Office of Service Member Affairs at the CFPB, the first director was Holly Petraeus, who just has tremendous moral authority for lots of reasons, but she was probably the only person at the outset of the CFPB's life who was agreed upon unilaterally across the aisle. And everything she was doing. Neither Democrats who loved the Bureau but didn't think it was aggressive enough, Republicans who hated the Bureau and thought it was too aggressive, all of them agreed that Holly Petraeus and her initiatives were really impressive and good. And of course that speaks in part to Holly, but it also speaks to, generally speaking, the kinds of issues you're talking about. There were certain communities of people for good reason who unite the country, and certainly service members are at the top of the list, and I agree we'll continue to see that. Jerry, what are you seeing or forecasting in terms of consumer financial service enforcement trends?
I'm forecasting everyone getting along and there being no enforcement activity or issues in the financial services world. No, in all seriousness, as Meredith pointed out, it's politics, right? So, and I think, Allison, you said too, the 2020 election cycle is coming up. People want to make a name for themselves. You've got a lot of state AGs and enforcement entities or regulatory bodies in the states that have former CFPB people or other very smart people within their realms, and they want to make a name for themselves. You have politicians on Capitol Hill who are running and want to further consumer protection. I mean, one thing that I always like to do is take a step back and think about where CFPB started, which was right after the mortgage market collapse and meltdown, and we're a decade removed from that. The mortgage market is sort of humming along. There's, the loans that were offered before that in 2004, 5, 6, 7 that were securitized and caused issues are no longer on the market. Of course, they could always slip back in, but you'd have to rewrite the rules at this point. So there are other areas of focus, and it seems to be the main markets of focus seem to be small dollar lending, student lending, and auto lending, which are sort of the three main markets that have, for lack of a better way to put it, a dearth of federal oversight or regulation setting them out. The Credit Card Accountability Act really changed the credit card market. The Dodd-Frank Act really changed the mortgage market. There's nothing sort of over auto finance. Student lending has some Department of Education requirements, but there's a lot of room sort of in those areas. And don't misunderstand me. There is obviously the Truth in Lending Act that covers a lot of the credit market for auto and others. But when you have a smorgasbord of state regulation, that leaves some room for candidates running on a federal or nationwide platform to try to make a mark by proposing getting rid of all student loans in the country, which, if you're trying to motivate the young vote, or even parents who put their kids through college vote, boy, that sounds like a great thing to jump on board with. So time will tell where things go, but right now I see a more cautious CFPB pushing more items through the supervisory side, pushing out education, pushing out more practical guidance and rules, and using enforcement as a last resort for those truly what they see is bad actors that, quite frankly, no one will support.
How about you, Liz? What are you forecasting?
So I certainly agree with everything that's been said. Only other thing that I see is a opportunity for private causes of action as the agencies look at bigger picture items for more creativity among the plaintiff's bar, and particularly I practice in Maryland, our district court and our small claims court, and challenging some of the default judgments that go through there. That's something I've seen a lot of interest in among the bar, and it makes sense as we're doing sort of big picture, as we're getting rid of anyone's student loan debt. That's great, but then there's an opportunity for some action on some of the smaller issues like auto lending or credit card debt and such.
So I see, this is Allison, I see three big trends kind of emerging. The first is that with the outset of the CFPB in 2011, you started to see kind of a melding of prudential issues and consumer finance issues. So the CFPB came online, and there was this received wisdom that the banking regulators, the prudential regulators, weren't using the consumer finance laws as aggressively as they could or should, or that there was this bifurcation between prudential and consumer finance. I think that that's been melded together, and I think you will just continue to see this trend of the OCC, the FDIC, the Federal Reserve, which of course regulate banks, and their service providers being pretty aggressive in the enforcement of consumer finance issues as well, because increasingly prudential concerns are seen as consumer finance concerns. You need to look no further than the way the Office of the Comptroller of Currency punished Wells Fargo for its consumer finance violations with respect to some of the account issues that arose in Los Angeles a couple of years ago. You're going to continue to see that trend. The other trend you're going to continue to see is a very aggressive state regulatory and enforcement trend, not only because there's a sense that the federal regime has relented a little bit, I'm not sure it has, but because the states are increasingly concerned about some of these big issues like preemption. Preemption being the idea that federal law overrides state law and state consumer protection laws. And at the outset of the CFPA in 2011, that was a huge issue. That was one of the biggest issues that animated the creation of the Consumer Financial Protection Bureau, which was the need to have federal laws that were aggressively enforced in the consumer protection space if you were going to have this preemption regime. And you've got a lot of states out there who are really pushing back and continue to push back on preemption. Meredith mentioned it in her discussion, and I think you're going to continue to see that. You're going to see the Department of Financial Services very concerned about the Office of the Comptroller of Currency trying to do a fintech charter. You're going to see the state AGs be aggressive in how they not only enforce their own laws, but they're going to continue to use the Consumer Financial Protection Act's prohibitions against unfair, deceptive, or abusive acts or practices. You're going to see much more of that, especially if the level of litigation truly recedes at the enforcement office of the Bureau. And finally, the third trend that I predict is that the CFPB under Kraniger is going to surprise a lot of people. I don't think that Kraniger is going to be in the vein of Mulvaney. I think she's going to be a little closer to a more, I don't want to say she's going to be quite as aggressive as Rich Cordray, but I think she's going to be closer to that than people expect. If you kind of look at her background, you look at where she's coming from, you look at even some of the things she's doing right now, I think you're going to see a more even playing field, maybe a more transparent CFPB, which is where we started with Jerry's discussion. But I don't think you're going to see a complete recession of enforcement activity. I think you're going to see a continued uptick of it, much to the chagrin of some people. I also think you're going to see maybe some more consistent application of the laws coming out of the enforcement office, which will hopefully give people a better understanding of how the laws get enforced and where they stand. So those are my predictions. I don't know if anyone else on our panel has any other final words that they want to add to this mix of forecasting as we move forward.
You know, I'll add one little piece of forecasting that will be interesting to see how it plays out, or if it does, which will be data security and privacy. The current director's background comes from that area in the Department of Homeland Security. And, you know, the Gramm-Leach-Bliley Act is one act that was only partially given to the CFPB to police or enforce, and that was over the privacy notices. So in order to do anything in the data security and privacy realm other than the privacy notices, the CFPB would have to use UDAP, and they're in the midst of sort of having those conversations in the sense of what is abusive practices. Data security and privacy is, at least should be, in my humble opinion, one thing that transcends politics, because everyone has a stake in having their data, their privacy secure, and knowing who gets to use that and how. So that's one area that I think we haven't really touched on, but might be something that we will in the future.
I definitely agree with that. You are increasingly seeing the Bureau kind of stretch its muscles in that space. It is somewhat hemmed in by the laws it enforces, and it does share a lot of jurisdiction with the Federal Trade Commission, which is much more aggressive in its enforcement of laws as they concern privacy. Thank you so much for joining us today. I'm Allison Baker. This has been a really great conversation. We will have in the next day or two our webinar materials, namely our PowerPoint, up on our website. And you can, of course, receive information about other webinars we've done, as well as our bi-monthly Consumer Financial Services Digest, which is a compilation of articles and notices that our team writes about updating and upcoming consumer financial services issues and events, as well as updating the laws as we see them. So thank you so much for joining us, and we look forward to having another webinar with